Hello, everyone. I am Joy Farrell, the managing attorney here at the Farrell firm. And I just want to thank you for tuning in today to our live broadcast. Today, I will be talking about three major changes to the Georgia child support laws that took effect July 2017. Here at the Farrell firm, our practice is highly focused on family law litigation. That litigation includes divorce, child support, child custody, visitation, paternity, temporary guardianships, grandparent rights, etc. We also focus our practice on the area of personal injury as well. Here at our office, we like to say that when clients choose to do business with the Farrell firm, that they're in for a life-changing experience. That's because we set ourselves apart here at the Farrell firm. We're not your average lawyers. We hold ourselves to a higher standard, and we take great pride in what we do to reach a level of excellence. We strive for excellence in service, knowledge, quality, and results. That's our Farrell 4 commitment to more in those areas. And our motto here at the Farrell firm is excellence is our standard. Maintaining our level of excellence when it comes to knowledge of the law is the reason for this broadcast today. Laws are constantly changing, and it is very important for you to have a lawyer who stays well informed on the law. And you can find more information out about our firm and how we are different by visiting our website at farrellfirm.com. And you can also stay in touch with us through our social media pages, Facebook, Instagram, and you can also find a lot of information on our YouTube page. So for those of you who tune in to us frequently, you know that in all of our live broadcasts, we love to answer questions at the end of the show, and we'll be doing the same today. However, I must give you this disclaimer. So by participating in this live broadcast, you agree and understand that information given today is for informational purposes only, and that if you need specific legal advice, you need to contact a lawyer, ideally us here at the Farrell firm, and schedule an appointment to receive specific advice to your information. Okay, so let's go ahead and get started on why you came here today, and we're going to talk about the changes in the child support. So the current child support laws haven't had any major changes in several years. In fact, the last major change to our current law really took place in 2007, so it's been 10 years. The 2017 legislative session just wrapped up for the year, and there's a few small changes, but very important changes that took place to the child support statute. These changes came through Senate Bill 137, so you can look that up and read the detailed information if you want to. The governor signed those bills on May 9th, 2017, and these new laws took effect July 1st, 2017. So as of today, 2017, the child support statute is now completely gender neutral, because as we move forward, we have more and more fathers having primary custody, and moms are having to pay support. So it's no longer appropriate to assume that the non-custodial parent is automatically the father. That's just a nugget for you. That's not one of the three things I'm going to talk about. So let's go ahead and get into the three major changes. The first change I want to talk to you about is the support for multiple children. Under the previous child support guidelines, non-custodial parents would get a child support order based on all the children with the same mom. And there will be one worksheet calculated for the multiple children. And that's what we've been doing for several years. And that was all fine and dandy until one of the children aged out or became emancipated in some way. And so what would happen at that point is that the parent paying child support would wonder how much they were supposed to pay now. So they don't have 3 kids, they have 2, how much they should pay. Should it be cut in half, or should they divide it by the number of children? People were confused as to what they should be paying. And the reality is you're supposed to pay the full order until you go back and modify it. So under the previous law, if you had a child age out, emancipate, or unfortunately pass away, you would have to actually go back through the court, petition the court, file a modification action, pay filing fees, pay lawyers, etc. to do what would be seemed obvious, to remove the child. But now, as of July 2017, parents with multiple children are permitted to submit a worksheet for each child, so that when the oldest child is no longer eligible to receive support, the child support will automatically decrease. This will save parents money and time, because it'll avoid the need for you having to actually file a modification of that support when the children age out. So if you have multiple kids, make sure when you doing your child support, you have 2 different worksheets, one calculating 2 kids, one calculating 1 kid, so that support order can stay in place. This new law does not prevent you from filing a modification when there is a need for a modification, which would be a change in your financial circumstances or a change in the needs of the child. It doesn't change that situation. The second change I want to talk to you about, this is going to be a big one for a lot of people, is parenting time deviations. Under the previous law, a parenting deviation, which is also known as a credit, was provided when the non-custodial parent had the child half the time or close to half the time. They would get a discount based on the amount of time they spend with the kids. Under the previous law, the deviation could only be used to decrease the child support amount, meaning if you were ordered to pay, let's say $1,000 per month in child support, you have your kids, more than every other weekend, you could ask the court to give you, say, a $250 discount on your child support based on your parenting time, and instead of paying $1,000, you would pay $250 less. Now, as of 2017, the parenting deviation can either go up or it can go down. And this means that if you have a non-custodial parent who does not spend any time with your child, does not exercise any visitation, makes no effort to see the child, there's a court order, they're not following it, they always cancel visitation, show up late, or only do part of it, you can now petition the court and ask the court to actually increase their child support obligation because they're not parenting the kids for the amount of time they should be based on the child support calculation. So long story short, if you're not exercising your visitation, or if the other parent is not exercising their visitation, you could be subject to having to pay more child support because you're choosing not to have an active part in your child's life. The third change I want to talk to you about is work-related child care expenses. Under the previous law, work-related child care expenses were to be included in the child support worksheet as part of the calculation for the child support. Now, as of July 2017, the judge or the jury has the discretion to remove the work-related child care expenses from the child support worksheet and doing the calculations when the child care is variable. So anytime you add child care to the worksheet, this typically skyrockets the amount. So for example, if there's no child care, your child support may be $450. If you add in child care, you may be paying closer to $900. Now the court, under the new law, can order the parents to split the daycare and then also pay the child support amount in the worksheet. This becomes really important when you have variable child care expenses. Say, for example, you have a 3-year-old or 4-year-old in preschool or daycare, I should say, and you're paying $800 a month. Well, when they start kindergarten, they no longer have those child care expenses. Under the previous law, you would have to go file a modification to be able to pay lesser child support and remove the daycare out. And that would be unnecessary when we all know that the child is starting kindergarten in August. And so now what the law is saying, in consideration of that child turning 5, we would say, okay, mom and dad, you split the daycare pro rata, and pro rata means based on your earning percentage. If one parent earns 60% of the income, the other parent earns 40%, you pay 60-40. And so you would split those daycare expenses accordingly and then also pay the child support amount. So therefore, when the child got to kindergarten, the daycare obligation will automatically go away, preventing you from having to file a modification with the court. This system is also effective for people who have a different arrangement for their child care, say like 2 or 3 days a week the child may go, or if you have a flexible schedule and you don't need child care every day, but you have to pay it sometimes. This gets more accurate in that you can actually have the other parent reimburse you for the actual expenses that you had versus kind of guesstimating an average annual basis. So what this is going to do is keep you from having to pay money to go and file a modification. You'll be paying the child care directly. The child care will be a part of the court order. The judge is instructed to put it in the order. So it is the order of the court, the obligation. So you still have to pay it. And so if you don't, you could still be held in contempt for not doing that. So now those were the 3 major changes that took place in 2017. Very, very important things and that you should know. And so right now we're going to go into questions. If you have any questions, you can start asking them now. Go ahead and start typing. While I'll give you a minute or two to get your questions together, I'm going to just give you a little bit of a recap on some of the previous information I've provided, or Attorney Roy has provided in some of our previous broadcasts about child support. Number one, child support takes into consideration the income of both parents, not just one. The income is based on your gross earnings, which means the amount that you make before any type of deduction comes out of your check. Number three, if there is no income, the court has a variety of ways to impute your income. That can be based on your earning history, your earning potential, and it can be based on your lifestyle. Or the court could impute you to minimum wage. Child support is calculated on an annual basis and is broken down into monthly increments. So support does have to be paid during extended visitation times, like over the summer, unless the parents agree that there's agree in court order that the support doesn't have to be paid over the summer. The only way to modify a child support order, and this is so important, and I say this in every video, the only way to modify a child support order is through a court. So no side agreements, because they don't mean anything, they won't hold up. So if you agree that instead of paying $1,000, y'all agree to $500, you're still going to be on the hook for that extra $500 if the other parent ever comes back and seeks that money. So official changes have to go through the court system. Another thing, child support can be taken directly from your paycheck. A lot of people don't like this option, but I actually think it's really good because then you don't have to worry about it, and you don't have to worry about going into contempt for falling behind on your payments. You can be incarcerated or have any type of license suspended, driver's license, barber's license, CDL license, any type of professional license, law license, dental license, etc., can all be suspended for falling behind on your child support. So those are just some of the highlights that I go through in detail on some of our other videos. So if you want detailed information about any of that, go back to our Facebook page where you are and scroll down and check out some of those videos. So now I'm going to answer some questions here. So are you saying that the non-custodial parent have the kids more than the custodian? We can't go back to court. I'm not sure of your question, Tabitha, if you can clarify it a little bit. If you're talking about the change in the law, if the non-custodial parent has the kids more than the custodial parent, the non-custodial parent should probably be seeking primary custody to switch it so that the custodial parent will then pay them child support if they're going to have the child more. But go ahead and clarify your question. If that's not what you mean, I'll of course answer it the way you mean. Rena says, for Georgia law, once a child turns 18, is it then when the father is free from child support, does he pay while the child is in college as well? Very good question, Rena. You have no parent has the obligation to support their child once they're emancipated. Emancipated means 18 or graduation from high school or until the age of 20. So if your child is 18 and graduates from high school, the support obligation ends. If your child is 18 and in the 10th grade, in this scenario, the father would pay support until that child graduates up until they're 20 years old. So if they're 21 and not done with high school, that's it. It stops at 20. That's the max. They either have to be in high school to go to 20, or once they're 18 in high school graduation, it stops. There's no obligation to support a child in college. The courts cannot order child support for college, but the parties can agree in a consent agreement that support be paid through college, but it's very hard to enforce it because it goes against Georgia law. Hannah says, if I have a current order, do I have to do a modification in order to have these new laws apply? Yes, you do. And if something's going to really benefit you to do that, the main one being the parenting time. So if you have somebody not exercising visitation, and you should probably modify for increase in the support. The multiple worksheets won't necessarily benefit you now because you're going to be filing the modified, but you'll have to file the modified then too if you keep it under the current law. So it's just going to depend. We can talk to you about it. You can contact us through a consultation, and we'll let you know if that's in your best interest to do so. Vickie, hey Vickie, how does child support work for parents of children who are developmentally delayed and will never be able to care for themselves? Glad you mentioned this, Vickie. We had a whole special seminar about this at the recent Family Law Conference. And previously, the belief was that you could do like lifetime child support. However, while other states have adopted that provision, the state of Georgia will only allow you to go to the age of 20. So we can't get you lifetime support, but we can get you increased support while that child is actually a minor, caring for those special medical expenses, physical therapy, medications, etc. We will do an upward deviation based on extraordinary medical circumstances, which comes under Schedule E in the child support worksheet, for allowing you to increase or decrease that support amount. Tina, if the mother is in California and the father is in Georgia and they have joint custody at the discretion of the mother, how would he go about filing for more visitation rights? So Tina, jurisdiction is gonna probably lie where the child is, and if the child's in California, Georgia will probably not have jurisdiction over this child to do a custody action. If there is a previous custody order that came out of the state of Georgia, Georgia may maintain continuing jurisdiction over that child, depending on what the actual court order says. So that's going to depend if Dad can file in California or if he can file here in Georgia. To petition the court for more visitation rights, you do not need a material change in circumstance like you do with a change in custody. Change in custody, there has to be something substantial to bring a new case. But for visitation, if you want more time, there's no standard to be met prior to that other than you wanting more time. So you can go ahead and file that action if Georgia is the proper venue. Oh, I just clicked on that one, sorry. Alicia, if my child is over 18, but the father is still behind on child support, does he still have to pay? Yes, if there is an arrears of child support, every dime of that child support will be paid, even if your child is 50 when they finish paying it. But just because they're behind and the child is already 18, it does not waive the obligation of what should have been paid. And you can continue to file contempt if they stop making the payment. If you need advice, either ask your question here or please call our office. I'll put our number up when we're finished and you can schedule a consultation to get some details. Oh, I see you asked a question coming up. I'm going to get to it. Antrinell, you need to go back and watch this after we posted. I went over the 3 new changes. I have been taking care of my sons since 9 years old, and he is now 14 and soon to be 15. I had temporary custody all that time and was granted full custody, but I was ordered to pay your $30,000. I'm going to assume that maybe for those previous 9 years, there was a child support order in place that maybe wasn't being paid. $30,000 sounds like an arrearage amount to me, which means accumulated amount of child support that was not paid over a period of time that you have to pay. So even if you have custody now, if there's child support from when you didn't have custody, you're still going to be on the hook for paying that. Okay, I think I have answered all the questions. No, I'm giving her $30,000. Not sure why you're giving her $30,000. Again, I'm going to assume that's for arrearage purposes. It was an order to give her $30,000. Okay, I'm going to, again, assume that's for arrearage, but if you want us to take a look at that order for you, just give us a call, and we will sit down, look at the order, and see if you have any options, and see if it was accurate. And we kind of have the same last name, Michael Farrell. Thank you, I appreciate it. I just try to help the community because knowledge is power. We perish from a lack of knowledge, so I'm trying to give knowledge to the people. If the custodial parent never gets the child, are you able to get an increase? Also, if they file bankruptcy, can they put arrears under that case? Okay, yes, if they never get the child and they have visitation rights, you can get an increase in that support amount under the new 2017 laws. Child support does not go in bankruptcy, so no, you can't put your debt into the bankruptcy to go under the payment plan. But child support arrears also cannot be bankrupted. So you don't have to worry about it. He's going to always owe it, regardless of the bankruptcy. Who does case law follow, the non-custodial parent or custodial parent as far as county-wise? I'm going to need you to clarify that, because our case law is the state. That's what we follow in the state of Georgia, so it doesn't matter for the county, and every judge is different as far as the way they're going to rule. So I'm not sure exactly what you're trying to figure out, but the laws that I'm citing to you is Georgia law. And I think that is all the questions. I'm going to give you guys another minute because sometimes as soon as I get off, I miss questions and then I feel bad. Okay, so we have another one. If a father quits his job right before child support court and then the state sets him a minimum wage and then he goes out to get a job, will I have to wait the entire 2 years before getting an increase? Absolutely not, Adriana. I'm assuming this was probably a case with child support services because only they would put him on minimum wage when he had a job right before court. But no, you should file a modification of child support immediately based on his new income. And you can do that right now because of the change in financial circumstances. Yeah, you do not have to wait at all for that. Okay, any more questions? Okay, I think I'm going to get ready to wrap up. I think that's all the questions I'm seeing come through. Oh, and also, Adriana, if the court imputed the income, depending on if the agency did it or the judge did it, there's like this 90-day period. If you find out they wrongfully imputed income and you have substantial information showing that he actually makes more money now, within that 90-day period, you can actually get back in front of the court to have them reconsider that child support versus actually filing a child support action and paying a filing fee and doing all of that. So depending on how long ago this was, the order came out, you may have an opportunity to change it a lot cheaper. If I stay in one county and the other in another, can the case law be moved closer to the non-custodial parent is in Georgia? Okay, for Georgia to have jurisdiction, both on a custody matter or child support, y'all need to live here. And depending on who files the action, that's what county is going to go in. So you file in the county of the defendant. So if you've been filing against the other parent, you file in their home county, whether that's the Gwinnett, Fulton, etc. If you need to move, you don't move a case for any reason unless jurisdiction or venue is improper. But if they live there, then it's proper. Yes, we handle custody cases. Custody, divorce, child support, temporary guardianships, grandparent rights, etc. We do all of that. If the father is paying his order but can't see his kids, what should he do? We don't even know where they live right now. Okay, so the first step we got to figure out is if the father has any rights, meaning has he filed a legitimation in the state of Georgia. If he has not filed a legitimation, he does not have any rights to see the kids, and that would be the first thing I would advise him to do, would be to file a legitimation action. However, we file legitimation actions in the county where the mom and the child live, and so that would be really important to try to find out. So I'll work really hard to try to locate where the mother is so you can file properly. Once you file that, then he can get his custody and visitation rights and go from there. But never wait too long to file legitimation, because despite popular belief, legitimations are not automatic. There's a time frame called opportunity interest, and you can waive that opportunity interest to legitimate your child if you wait too long to do it. Chris, child support is out of state. Do I have to abide by the state the child resides in? Chris, if you live in Georgia, you should be following under Georgia child support laws, because Georgia is who has jurisdiction over you. So if you have a child support order that's not the state of Georgia, you need to have it transferred to the state of Georgia and do it under our laws, so long as our laws are more beneficial to you. Now, if where you are is more beneficial, then just keep it how it is. I wouldn't change it. Okay. I think I have answered most of the questions. I got a few more seconds. I'm gonna give y'all this spiel about how to contact me if you want to talk more. You can schedule a consultation, 678-973-2803. You get those are $150 for an hour here in our office. We would love to meet you and help you get your case going. Okay, I see some more questions popping up. I see you. I'm gonna get you. Marina, do you all consider children that he does not have on child support? So Rena, the child support worksheet considers two types of children other than the children being calculated. The first type is pre-existing child support orders. So he would have to have a court order paying child support for those children to get any type of credit in the worksheet, so long as they were orders before this order is coming down. And the second type of child that's given credit on the child support worksheet is called qualified children. And qualified children are children that you care for, meaning they live with you primarily, you don't receive any financial support from the other parent. You would get a credit on the worksheet for those children. But if he is not the primary parent for those children, not receiving any support or doesn't have any pre-existing child support orders, he would not, those other children would not be considered in calculating your child support. Do they have to have a legitimization if they are divorced? They were married when the children were conceived. Okay, good question, Pamela. No, if children were conceived and born during wedlock, the children are automatically legitimate. And then the custody and visitation should have been established in the divorce decree. So you need to check the divorce decree and see what it says. And depending on the year of divorce, Georgia laws have changed. And at one point you could just get divorced and they didn't say anything about custody and visitation. But now in order to get a divorce, the court is supposed to have a parenting plan in place and a visitation plan in place. So unless he wasn't at court or something like that, or he didn't get visitation rights, it should be in there. However, if you look and it's not in there, what we can do is file a petition to establish visitation rights and determine what the custody is and go from there without having to establish the legitimation. What if you're not paying child support but the kids want to live with the father? What if you're not paying child support but the kids want to live with the father? If kids want to live with their father, they need to be 14 years old to be able to make an election of who they want to live with. However, an election is not an end-all be-all. The court takes into consideration, but at the end of the day, it still has to be in the best interest of the child. If the child goes to live with the father, then yes, you will be expected to pay child support. Both parents are expected to have a child support obligation to help raise children that they created. So you would be expected to pay child support just like dad is expected to pay you child support right now. I'm just tuning in. How can I get my case switched to Georgia? Depending, if it's through child support services, just contact them and tell them you want it moved to Georgia. The father needs to be in Georgia if that's the one paying support. Then they can just transfer through state agency. If it's an out-of-state order, we can file to have it domesticated here in Georgia so that Georgia can have jurisdiction over it. There's a couple of ways to do it. Not hard though. What about my income change reduced, therefore you need to have your child support reduced? Okay, so if your income reduced by more than 25%, it needs to be really a 25% change for you to be able to file the modification. There needs to be some reasons as to why it got reduced. If it was voluntarily, are you looking for jobs that was paying what you were paying before? Because just because it reduced, the court won't automatically give you a modification, because sometimes people take lesser paying jobs to pay less child support or try to get more child support. So we look at it very closely. So the factors around your reduced income is going to play a major part, your earning history and earning potential. But just it changing, if it's 25% or more, that will qualify you to file the modification, but you want to be very careful and make sure it's advantageous of you to file it, because sometimes it could go down versus going up. I'm about to set up child support legally. It's not pre-existing, but I have always given her support, but never set up through the state. Do I have to back pay? Getting back pay support is very difficult. You have to have all the receipts and everything. Child support becomes legal obligation when you actually get a child support order for the support. Anytime you're paying somebody child support and it's not official, never do it in cash. I can't express that. Never pay in cash. Always pay in something that's documented. A check, bank transfer, or money order. Preferably something going through your bank accounts where it's easy to find, because sometimes we lose the money order receipts and can't prove it that it was received. Would you have to still pay child support if the child wants to go live with dad and he owes over $25,000 in arrears? Good question, Erica. When I've had cases like this, there technically will be a child support order entered, but what we'll say is, so let's say you're supposed to pay $500 a month, which is $6,000 a year. Your support is kind of paying back all the money he's owing you. So no, you technically won't exchange hands on that support, but your support, your quote unquote paying, will be reducing his $25,000 in arrears. Robert, I pay support, but she won't let me see or talk to my son. It's been a year. Robert, you need to lawyer up. Let's the easiest way I can tell you. Give us a call and we'll put that to an end real quick. You have a right, you can pursue your rights if you don't already have them. So anybody else? I think I got everything. If I miss you during the live broadcast, today is Friday, August 4th. Some of you guys come on here later and get mad for me not answering your questions, but it's not live. So if it's not 12:30 on Friday, August 4th, you're missing it live. And so what I try to do is after I finish, I try to come back through every couple of days and answer questions that come through later, so that everybody, you know, gets responded to. That's why I do this. And probably next week sometimes I'm going to go live and just do a straight question and answer. So you can just bring all your questions when I show up next week and ask whatever you want to, and then we'll just have an open dialogue about it. The child is almost 18 and not attending school. He still has to be emancipated, Chris, and I would try to get him emancipated if he's a school dropout, because he has to legally be emancipated through the court system for you to be able to stop that payment. Otherwise, you're going to be on the hook till he's 20 on that child support. My husband has 3 children from a previous marriage. He got custody of one 3 years ago. The court advised that the mom was supposed to have a reduction of the amount paid to her since we had custody of one. We declined due to her finances, but they have increased. Okay, Katrina, that was very sweet of you to decline that. But y'all stop being nice out here worrying about people's financial situations. If it were him, he was paying child support, she need to pay child support. It go both ways when we do this. Okay, there's no discrimination here, but since y'all were all nice and everything, what you need to do is go back and file a modification action and get that taken care of ASAP. Okay. If non-custodial parent was put on child support after the father was already on support, does that make the first custodial parent support order be reduced? You talking about for different children, I'm assuming? First baby mom to the punch always win. They always get credit. First baby mama don't have reductions in her child support. The second one, third ones, fourth ones, they get reductions based on the first child that was on the support. If I lose my job or get laid off, will that affect my child support? Yes, possibly. Depending on how long you think it's going to take you to get another job, how much you were earning, how long you were in that job, etc. The courts just don't automatically modify support because you lose your job, because by the time we go to court, you probably will have another job. So we have to look at the circumstances surrounding it to see if it's advantageous for you to go ahead and file a support. Could you go over or put a link to the changes in laws? I don't have a link to it, but you can just Google Senate Bill 137 from Georgia, and you should be able to. It's going to be real complex, and the way they wrote it and everything is like 35 pages. I've kind of thumbed it down for you, but that's where it is, and you can always go back. Once I get off, this video is going to repost itself to our page so you can catch the beginning. I think it's like the first 10 minutes that I kind of go over everything in detail. Can we go back and adjust now due to her increase in income and lifestyle? Yes, you can, Katrina. I pay support for my son, and the court order says I can't see my son, talk to my son. I get my son, and he has refused me for 3 years. Okay, Jennifer, this is terrible. So the court says you can't talk to your son. You need to give us a call. We need to see why that is and see if we can get that order modified for you. Chris, what about paying up for the current month? You need to let me know what that question is. I'm not quite sure at what point you type that and what you exactly mean by that statement. Is it true that if they don't have a current address, the order can't be enforced? What I think you're probably talking about is working with child support services. They like mail a letter. If they can't make service, they don't issue the support. But no, I mean, if you know where they are and we can make service, and once there's a child support order, an order can always be enforced. You probably just need to hire private lawyers like us to pursue it. When you're working with the state, they don't have time or resources to be chasing down people for your dollars. That's why you need to come and hire private lawyers. Can there be more than one IWO issue out on the child? IWO, for those who don't know, is an income withholding order. And there should just be one IWO issued to your employer for one support amount for one per child. So if that's not right, you might need to get some amendments. There might be some clerical errors there. Soon to be ex-husband has temporary custody and will not allow me to see the kids. Anything I can do until divorce is final. If there's a temporary custody order, Tabitha, there also should be a temporary visitation plan. Unless the court says you don't have visitation or supervised visitation, then you don't have it. But if you're supposed to have it in the temporary agreement or a temporary order, then you're entitled to exercise that. And if you're not able to do that per that order, you need to file a contempt of the temporary order, because you can still file contempt actions even though the case is not final. And you should do that immediately to show the court that your husband has a problem co-parenting, and hopefully that will weigh on the final decision as to who should get primary custody. Because if you can't co-parent, you don't need to have custody. If the child receives Social Security due to her dad, is that considered child support? Yes, the dad does get credit for the Social Security that the child receives. So, for example, let's say dad's child support order is $500 per month, child receives $300 per month in SSD. The father only needs to pay an additional $200 to the mother to make that total a $500. Is the change just Georgia or national? I'm just talking about Georgia law. Every state has their different laws. Jennifer says, I've been dealing with DFACS for 10 years with my daughter in Atlanta. They say if he's not served, they will drop the case. It's been going on for 10 years. They have all the info. I feel let down on no hope. I'm low income and caring for a disabled child. Jennifer, that is very sad and unfortunate. I'm sorry that you are dealing with that. Trying to serve with the state is very difficult because all they do is mail a letter. You probably need to hire private counsel. I know it's probably difficult for you because you're low income, but I would try to reach out maybe to legal aid offices that can probably help you file a private action, and then you can send a private processor or the sheriff out there just to serve him versus sending a letter in the mail that keeps getting sent back. 10 years is unacceptable. I can't talk to my son. I can see him. That's what the court order says, but the father has refused me for 3 years now. Okay, so if you can, yeah, great. Then you need to file a contempt action immediately and possibly a modification of custody if he keeps on with that behavior. What are the custody rights for the non-custodial parent that lives in a different state that is on child support but he doesn't pay? Custody rights, if you live here, he would need to pursue his custody rights where you and the child are. So if he doesn't have any, he doesn't have any, so none. If he doesn't pay child support out of the other state, you need to contact a lawyer in that state or child support services, have them enforce the order and do a contempt action. During my case, they took off $100 of his child support because he was paying some of the daycare fees. This was 3 years ago, and she's no longer in daycare. Can I get that changed? When can I get this modified? He's refused to see her once a month on child support. You can get that modified right now, girl. Just give us a call. My something is receiving Social Security disability, so now my daughter receives. Is that considered child support? Yes, but that doesn't mean you should only get that. You probably should get more. You would need to see by running a child support worksheet. What changes are happening in Georgia? I tried to place my son's father on child support, and they said they are closing the case so they couldn't locate him. I know where he is. Okay, this is the really frustrating part about child support services, is that they really do a terrible job serving people. That's why you just need to make the investment to hire a private firm like us or any other family law firm to actually pursue this and go super hard at it. Like, don't keep waiting for them to do it. You just need to make the investment and go after him. If you know where he is, we can get him served in a matter of days. What if the non-custodial parent keeps quitting jobs, which is making it hard to get child support, but I have to wait for the new job to get information? No, Angel, and check out one of our other videos on child support about imputing income. But whatever he was earning or what he usually earns, we can go ahead and put a child support order based on that. He doesn't have to have a job at the time child support is ordered to start getting you some money. Now, if you enter child support support, say he's making $15 an hour, then he gets an actual job making $20 an hour, you can just modify the support. Him quitting jobs, hopping around should not exclude you from getting some type of financial support. If the custodial parent make money by doing makeup for a living and have a good clientele, do child support take that into consideration? Marquita, that's probably under the table money. When I say under the table, I mean it's probably cash money. So it's not going on record in the Department of Labor. The only thing Child Support Services do is look at the Department of Labor. They would probably come up unemployed in the Department of Labor. So we would have to do a lot to prove how many clients we think they're getting per day, how much money we think they're making, their lifestyle. We look at their bank accounts and everything else to come up with a monthly amount. And then we take that into consideration when determining the child support. If you go through child support, you're just going to get it put in at minimum wage, which is $1,261.50. Chris, can you pay child support by the month? Yes, it is calculated by the month. You pay it monthly. You handle my divorce. My arrears have been paid in full since March, but they would not change the arrears monthly back on my original amount. Hey, Chris, how are you? Hope you're doing well. Give us a call. We can get that changed for you. Just set up a consultation to come back in. I feel as a mom, I have no rights. These orders to pay, but it's not quit job, so he doesn't have to pay. Just call us, girl. We can fix that for you. Not a problem. You have a lot of rights. What are your fees? How can I get this started? They won't take it out of his check. He works for the IRS. He pays monthly. Just don't know when. He even lied and told them it was temporary. It was really permanent. Our fees, roughly for most cases, started like $2,500 plus the filing fee in each county. My daughter has been to at least 4 different schools in 2 to 3 different states since living with her mother while she job hops. Isn't there a law that anytime the child is moved from the state that was documented on the original, or the court be notified? The court should be notified. Most custody orders have a provision where the custodial parent has to notify the non-custodial parent, not necessarily the court. Some states require that, but Georgia doesn't. But she does have to notify you, usually 30 to 60 days before any of those moves happen. Jessica, can we take your case? Do we take payment plans? We will have to meet with you on a consultation to make a determination if we will take your case. Our payment plans are somewhat limited, but it depends, varies case by case. Do you handle cases not dealing with child support guardianship? Yes, we do. We do a lot of custody actions and guardianships. Guardianships can be given with consent of both parents, and they're supposed to be terminated upon petition of the court by the natural parent. Jamal, when the kid turns 18, do the payment change if there's on a case with other kids on law. Under the new law, that would be the case, but if you already have an order, you're under the old law, so you're going to have to file a modification to get that support changed. Okay, I think, why doesn't the system take men living expenses into consideration? The system doesn't really take anybody's living expenses into consideration unless it directly affects the child. That's going to be child care, medical insurance, vision, dental for the child, tuition, extracurricular activities, etc. For the child. Those are the expenses taken into account. They don't care what mom's expenses are or what dad's expenses are. It's all about the kids when it comes to this. What happens when I'm not notified about the move? You need to file for contempt, probably under the initial order that says it. And when you guys have these issues, you can't just sit around and wait and like be aware of them and not do anything about it. That doesn't look good. When something happens, you need to be aggressive, take action immediately. Let them know that you won't tolerate this type of behavior, so it's not going to go on for the next 10, 15 years. Go ahead and use the court orders to your advantage. If you don't understand your court order, make the investment, sit down and talk to somebody about the support order so that you know what your rights are. If you have a custody issue, you need to know what your rights are. If somebody's supposed to be seeing the child, you need to let them see the child. If you have rights to see your child, you need to go and see your child. If you're supposed to pay child support, pay your child support. If somebody's not, enforce these orders. So you telling me I have to pay child support and not pay my rent? I mean, that's not what I'm telling you, but I know kids got to eat. So, get a second job or budget accordingly. Reduce your rent. All right, y'all. I think that's it for today. Again, if you guys want to schedule a consultation to come in and meet with us, our number is 678-973-2803. And you can give us a call today. We're here for a little while longer. We can get you set up to come in next week. Again, that fee is $150. I hope that I gave you guys some good information today. Please share this broadcast with other people so that they can become informed. If you really want other information, just browse our Facebook page and get some of that information. All right, you guys have a great week. And don't forget, like I said, I'm going to go live next week, myself or Attorney Roy, and we'll just take a live Q&A session. We'll just talk about whatever you want to talk about. So bring your questions. Y'all have a good one.